Hi, folks. It's Andy Stautz at Stautz Law. I am back with another, I guess it's an estate administration topic. This one's kind of an oddball, and it's not going to be my most focused talk ever, but it comes up so much. And the question is, how do I get the house? How do I fix the house title? And the scenario that comes up over and over is, oh, my grandma, owned the family farm and she died, and so's name is still on the title, but he's gone, and, my cousin's living there. All of these situations where there's some property, real estate always, we're not talking about personal property here. There's some real estate, there's some house, and it's still titled in someone's name who's gone. And the question is, okay, how do we bring it up to date? What happens? You know, and a lot of times this happens when either there's a mortgage or there are taxes, um, and something changes there. So, in theory, when someone dies, the personal representative, if there's a estate administration, or the beneficiary, if there's a transfer on death deed, maybe needs to assume the mortgage and fix it, like let the bank know that someone else is paying the mortgage. Same thing with taxes, right? Like, in theory, you should get it passed down and make sure that the person who says they're paying taxes is the one actually paying taxes. Um, Obviously, that doesn't always happen, right? So you've got people who are paying a mortgage in a dead person's name, or paying taxes in a dead person's name, which is, you know, not a huge deal as long as things are getting paid. Most people are usually willing to just kind of let it slide. But if there's a change in circumstances, that's when it comes up, or someone stops paying the taxes, and now there's a foreclosure sale or a tax sale. Um, so can you fix it? Usually, yeah. It just kind of depends on different factors. So, um, for example, if there's a will, that's great. Usually, the rule is you have to probate a will within 3 years of a death. Now, sometimes these cases come to me way after. Fortunately, there's an escape hatch in the Indiana code that says, oh, by the way, though, you can probate a will specifically to clear title or pass title to something that's still titled in the decedent's name, which is, perfectly this situation, right? We've got a house, it's still titled in someone's name. They died 5 years ago. It's like, okay, we're past the 3-year limit, but we can still introduce a will, if there is one, to say, here's how it needs to go. Sort of similar for survivorship affidavits. So if there's a joint titling situation and you need to resolve, who got the property by survivorship, you can file a survivorship affidavit. As far as I can tell, there's not right in the statute a limitation on when you can do that. And sometimes it happens, years later. Sometimes you need to do a survivorship affidavit to clear up a joint title situation, and then a probate. You can kind of stack these methods. And then the other technique, which is probably deserves a whole talk of its own, is what's called a devolution affidavit. And this is basically a deed that you can do without a probate administration, and it's supposed to show that title to the real estate passed. Problem is, if it passes by will, there's another clause in the probate code that says you have to probate the will for it to be effective. So arguably that means you need to do the probate of will for a specific asset. In intestacy, you don't necessarily need to do that. You're just still, depending on your title company, some title companies take the position there's still a cloud on the title because until there's been an administration, the property is subject to possession of the personal representative. And again, that gets arguable, but it's something to consider. So that's just a bunch of considerations. This is really a problem-solving area. So, if there's a house and it's titled in the wrong person's name and you're wondering who gets it or whether you can get it, it just depends on the facts. And it depends on what intestacy rules say, what the will says if there's a will, other heirs. And it's problem solving. You use these different techniques to try to make sure it goes in the right place, which can be really fun. You just don't know how it's going to turn out until you get advice for your situation. So if you're dealing with something like that, give me a call. Love working on these cases, and I hope this talk has been helpful as kind of a general overview of what's possible. Thanks. Bye.